I warmly welcome you to the concluding session of ALRAC 2016, and I warmly welcome members of the public and interested persons to this public and open session, a forum on human rights and family violence. As every one of us in this room is acutely aware, family violence is one of the most prevalent human rights violations in Australia and worldwide. In this forum, we will be considering how using a human rights perspective can assist in understanding and ultimately preventing, which is the purpose of all of us, family violence. There will be two papers presented, first by Professor Gillian Triggs and then by Dr. Eric Qua, and then there will be time then for questions and discussion. So commencing with Emeritus Professor Gillian Triggs. As you all know, of course, she is President of the Australian Human Rights Commission. She was previously Dean of the Faculty of Law and Challis Professor of International Law at the University of Sydney from 2007 to 2012, and Director of the British Institute of International Comparative Law from 2005 to 2007. And in her previous iteration, I have happy memories, which Gillian and I have just been discussing, of our time together on the Faculty of Law at this university. Professor Triggs is a barrister and a Governor of the College of Law. She has, as we all know, combined an academic career with interests with international commercial legal practice, and has wisely advised Australia and other governments and international organisations on international legal and trade disputes and a myriad of international issues. Her focus as President at the Commission is on the implementation into Australian law of the human rights treaties to which Australia is a party and is morally obliged to uphold, and we hope legally, and to work with nations in the Asia-Pacific region on practical approaches to human rights. She is, as you know, the author of many books and papers on international law. Professor Triggs, we are proud of your work and we are proud of you.
It is a great pleasure to be part of this final session of the conference, and to have been invited to talk about this extraordinary global phenomenon of domestic violence. And here, back at my old law school, I would like to acknowledge the traditional owners of the land, the Wurundjeri people of the Kulin Nations, and of course respect their elders past and present. I'd also, of course, like to express my respect and pleasure that we have so many representatives from the Pacific region here. It's really a delight and wonderful to be sharing this platform with Dr. Qua. I think it's so important for Australians to be better connected with our neighbours in the Pacific, and there's so much work that we can do together. It's also, of course, a great pleasure to be with you all from the law reform agencies. Well, the phenomenon of domestic violence is one that we're all very, very well aware of. It's been an extraordinary year. You're all aware of Rosie Batty's selection as the Australian of the Year and the advocacy that she has achieved in bringing this issue to the forefront of Australian consciousness. Now, of course, we have David Morrison as the new Australian of the Year, also taking this issue further. Well, what I would like to do in the time that I have is to talk about the opportunities that the law and the legal profession, and particularly law reform agencies, have in preventing domestic violence and protecting those subject to it. I think there is scope for considerable law reform, particularly in the area of coronial inquests and achieving some form of national response to coroners' inquests, and I'd like to move to that as we go through. But I'd like to begin with, if I may, some stories, because they really do, I think, focus the mind on what it is that we're dealing with and the complexity of what we're dealing with. And I'd like to begin with a story that is still not quite over. We await a coronial inquiry into the death of Miss Du. The facts that I'm about to give you are on the public record. They're very well readily available. She was a 22-year-old Aboriginal woman in Western Australia, in Port Hedland in the Pilbara region. And she died about 2.5 years ago. The police were called to her home by her grandmother when Miss Dhu had been assaulted over a number of weeks, but on the instant day, at the hands of her partner, who had a reputation for violence and against whom various violent protection orders had been issued. When the police went to the house, they, of course, do what they always do. They checked their records electronically and found that she owed $3,000 in parking fines and driving without a licence, but relatively minor matters, but totalling $3,000. So she was promptly arrested and held in the police lockup. And she complained repeatedly that she was suffering from the violence that she got at the hands of her husband or partner. And she was told by the police that she was faking, but nonetheless they took her to the local hospital, where the hospital staff were advised by the police that they believed she was faking. The hospital staff diagnosed her as having behavioural issues, but did no tests whatsoever, and she was discharged back to police custody. Again, she complained of illness and was taken to a hospital again, and was again returned to a police cell without treatment. Finally, when it was clear on the CCTV footage that she was in agony, she was put back into the police van, not an ambulance, but the police van, to be taken to hospital, and she died on the way. She, in fact, had sustained injuries to her ribs, which, because the condition had not been treated at all, led to septicemia and pneumonia. So she was literally dying over those various visits with virtually no assistance. One of the matters of concern to me is that 2.5 years later, we still have no coroner's report. And this story is one of hundreds of often impoverished victims of domestic violence, imprisoned increasingly under unjust fine systems, some dying in police custody, one even quite recently under the recently approved decision of the High Court of the paperless arrest laws in the Northern Territory. But in giving you those very sad details of domestic violence, what I wanted to do was to show just how complex these issues are. That instead of investigating the core issue that was that the police had been called to the house to deal with, they were not dealing with that. They were using the opportunity to arrest someone for fines and then fail to take proper notice of the medical evidence that was available. And there's one other case that I think you may know of or have heard of. That's the case of Mrs. Andrea Pickett. This was a woman who died again from domestic violence. She was literally hacked to death with a knife by her husband. This was 2009, some years ago. We do have a coroner's report in this case. She was a mother of 13 children, had been married for 23 years, but recently separated from her husband. He was in prison, or had been in prison, for offences related to domestic violence and attacks on her. He was released on parole, but there was a violence restraining order against him. Fearing attack for particular reasons over the previous few days, she sought the protection of a refuge, the crisis care centre run by the Department of Child Protection in Western Australia. But she had 8 of her children with her, and because there was a rule in that childcare crisis centre that you could only take a maximum of 5 children within one family, she was denied admission and she was killed the following day. The Australian Human Rights Commission was granted leave to intervene in the WA inquest in 2012, and we made a number of observations about the failure of the parole system, the failure of the police to investigate the allegations of domestic violence, the failure of any integrated system to try to put the facts in relation to this woman's life together, the failure to respect the rights of the child, inadequate police training, and an almost complete lack of Aboriginal cultural competence training for police or any of the officials that dealt with this woman. Well, these cases can demonstrate just how marginalised by society these people can be, and how their cases are largely ignored or not treated in an appropriate way. And I thought before we go into some of the elements of the law, we might have a look at some of the facts or recent responses. Our Prime Minister, of course, has said we must elevate this issue to our national consciousness and make it clear that domestic violence is never acceptable in any circumstances. So that is a very encouraging start, and you'll know that he has recently funded, to the tune of 100 million, some monies to go towards the protection of women in these circumstances and to better understand the background to domestic violence. A point that I must say I was not aware of until I sort of started to work in this area was just what a global pandemic domestic violence has become. It's quite extraordinary just how in any country we go to as part of the programs for the Australian Human Rights Commission, we find that near the top or at the top of every agenda for human rights within the countries that we work with, it's always domestic violence, violence against women. And the extraordinary phenomenon appears to be one which is true across developed and developing countries, and it's true across social and economic groups or classes in society. So it really is something that appears to be endemic to the human condition, but hopefully one that can be addressed. 35% of women have experienced some form of sexual or physical violence, most from their intimate partners or family members. And it's now estimated that 1 in 3 women will experience violence in their lifetime. And the statistics are very, very shaky in relation to deaths. In Australia, we are certain that at least 1 woman a week is killed by her partner or intimate or former partner. But there are other estimates that at least 2 a week have been killed. Certainly 78 on our assessment were killed last year. Other NGOs estimate this at least 2 a week. But it's the failure to get accurate information about these deaths in family violence circumstances that is leading to the law reform project that I want to talk to you about towards the end. And the statistics globally are quite extraordinary. Through the United Nations, there are thought to be more women living in intimate relationships characterised by violence than malnourished people on the Earth's surface, which is quite an amazing fact. The cost. It's always interesting, I find, working in the human rights area with the Commission, that I can talk about the international law and I can talk about the damage done to women's lives, but one of the things that is most powerful is the sheer cost of domestic violence to a modern economy. And estimates are made of 13 billion domestic violence costs to the economy in 2009, with that expected to rise by at least another 2 billion over the next few years. And one important element is that employers do bear a significant element of that cost, leading to concerns about the way in which this works in the workplace. Well, what about the international law? Well, firstly, we have the International Covenant on Civil and Political Rights. I think you're all familiar with that. The right to life, the right to safety, the right to equality before the law. The United Nations has created a declaration on the elimination of violence against women and defines it as any act of gender-based violence that results in physical, sexual or psychological harm or suffering to women, including threats of such acts, coercion or arbitrary deprivation of liberty in public or in private. I remember when I was at this law school in the 60s, the idea was then a very strict division between public and private. And what happened in a marriage or what happened in an intimate relationship was one that was of no concern to the courts. And there was a phrase that I always remember graphically from an English judge saying, it's not for the courts to look between the sheets of a marriage or a relationship. And now I think that we've moved a long way from that understanding of the law, and here we have a definition that, of course, includes public and private acts. The Convention on the Elimination of Discrimination Against Women makes a specific provision that gender-based violence is a form of illegal discrimination, and the United Nations General Assembly, in a declaration on violence against women, have said that that violence is rooted in historically unequal power relations, social norms, stereotypes, poverty, drugs and alcohol. And one thing that has certainly emerged from our work at the Human Rights Commission and confirmed by sociological work is that almost invariably when women are subject to domestic violence, they are in a position of a lack of control, that the male perpetrators have been ones who have exerted an extraordinary level of control over their lives. And in some respects, that does reflect economic inequality, the inability of women to get fair access to work and to build their economic ability to determine their own independence. And I always think of the Virginia Woolf novel, A Room of One's Own, that ultimately this is so critical for women, that they must have equality of access to employment. And I'll come back to that point in a moment. Well, gender-based violence, of course, is a human rights issue. It affects the well-being and quality of life, access to education, access to housing. Women who are subject to domestic violence often don't have the economic ability to go out into the community and get different housing. They can't afford it. Or if there's a background of domestic violence and they've lost the lease on one property, they can find it virtually impossible to get housing in another. And so the stories go on. A lack of access to employment and health. And governments, of course, have legal obligations to prevent, investigate and punish violence against women, and, of course, to provide access to effective remedies. Well, Australia does have a national action plan to reduce violence against women, and it's recognising that there is a human right to live safe from violence. But, of course, Australia is subject to international scrutiny in relation to the effectiveness of our national plan. And a few years ago, in 2010, the CEDAW committee specifically raised concerns about the level of violence against women in Australia. But most particularly, the Universal Periodic Review of Australia's human rights record in the UN Human Rights Council has listed this as one of the top 3 concerns they have about Australia. Now, I did go to this Universal Periodic Review. It's a process that's come under the relatively reformed UN Human Rights Council, relatively successful United Nations body after the rather notorious behaviour of its predecessor. This is now seen as a body of some credibility, and Australia went through its 2nd periodic review in November last year. 110 states were there, and they get about 1 minute and 10 seconds each to make their points. But it was very interesting to sit there and listen to 110 states say that there were 3 core concerns repeated over and over and over again in that body. One was, of course, Australia's asylum seeker offshore processing policies. The second was the treatment of Aboriginal and Torres Strait Islanders in Australia, child health care in particular, and access to education. But thirdly was always violence against women. Now, I'm not sure if you're aware of the process, but after that criticism, courteous and in a calm and measured way in the UN, Australia has an opportunity to respond to those concerns in March this year, next month. And I will be going as President of the Human Rights Commission. I have legal standing in the UN to make a response to Australia's the criticisms made of Australia and Australia's response that is not yet available, but will presumably be available quite shortly. Indeed, if I'm to say anything sensible, I need to know what they're going to say. But of course, life is always about timing, and you will all know that Australia is now seeking a seat on the United Nations Human Rights Council, so that this is a very important opportunity for Australia in the next 2 weeks in the UN to accept or recognise the criticisms that have been made through this process, and to make some announcements about what will happen in the future. And my very sincere hope is that we will be able, as a country, to respond positively to the concerns and to ensure that some of the concerns I'm about to talk about in relation to women and violence are met. I thought perhaps I should say just a little about what the Australian Human Rights Commission does. We have a mandate to hold the government and the private sector to account for compliance with the human rights treaties to which we're a party. We are subject to, a part of our mandate is a number of international treaties that sadly are not part directly of Australian law. Now, this is a point that you will understand, but I have a lot of difficulty explaining to the wider wider public, and certainly not in a 1-minute grab on a radio interview. Very hard to explain to the public that we've been a good international citizen from the days of Doc Evatt through to Gareth Evans and the ratification of the the statute for the International Criminal Court. We've been a very good international citizen, and we've been out there drafting and supporting all of these human rights initiatives. But the curious phenomenon has been that we've not implemented those treaties in Australian law. So that although the mandate of the Australian Human Rights Commission is to hold the government to account for those treaty obligations, when I see the minister or we intervene in a court case, it's impossible for those entities, either at the political or legal level, will say, that's very interesting that we are a party to these treaties. But those treaties are not binding on the courts or on the minister. So it's a little bit like ships passing in the night, that I say one thing which I'm required to do by my statute, but a minister can reject what I have to say with relative ease, and indeed will do so. So we need some mechanism to pull down these treaties from that international bubble of law to make them part of Australian law. But the problem is compounded by the fact that we do not, of course, have many constitutional protections for human rights. The High Court implies a right of political communication. We've got a right to freedom of religion, to be compensated if our property is taken, and a right to vote, but very little else. And we're the only common law country in the world without a human rights charter. So making these arguments is a difficult one in practice. But we do have some legislation that's been critical, and one is the Sex Discrimination Act. We were one of the first countries to ratify this, the CEDAW Convention, and then we did introduce that convention into domestic law. So our job at the Commission is to receive complaints under the Sex Discrimination Act, and we know that 80% of complaints under the Sex Discrimination Act actually concern unequal access to employment. And I think that, in a way, explains pretty well immediately the position of women in the Australian environment. In anticipation of International Women's Day next week, I've been looking at the most recent statistics of the global index put together by the World Economic Forum. And the very good news, and I think it's been true for some years, is that Australia is #1 in the international community for having the best educated women in the world. We achieve a higher level of education across all social and economic groups in this country than any country, even ahead of Sweden and Norway, which is quite something. But then, if we look at our engagement in the political processes in our states, territories and at the Commonwealth level, we are 61st. And we are 71st on ministerial or cabinet positions. We're about 26th on the gender pay gap, and basically well down the list on a lot of the other indices of equality. So it gives you some idea that something has gone oddly wrong in Australia. That certainly in my generation, coming from this law school, I thought if women had education, they would be able to have the economic independence, and in that way, through equality, never to be subject to the kind of domestic violence incidents that we're seeing in Australia. But it's not proved to be the case, and we need to do much more deep thinking about how to deal with it. Well, because so many of the cases that come to us arise in the context of employment, we've been working with the business community to ensure that they put in place leave or flexible work arrangements for those women who do or who report domestic violence. And we're encouraging a culture now in which employers will make available counsellors to be able to speak to women who are subject to domestic violence. But now I come to the question that's been of particular concern to me, and that is the problem of standardised national reporting. It seems fairly clear that the people who know most about how and why the misdo cases arise are the coroners, because they will tend to look not at the instant facts, or not only at the instant facts that led to that woman's death, in these extreme cases of death, because most cases of domestic violence, of course, do not result in death. But where they do, the coroner has a jurisdiction and typically will take the time to look at the history of the woman and the various services that she may have appealed to, or the many causes that may have led to this, to her ultimate death, typically at the hands of her partner or family member. So they're an invaluable tool, but we became aware at the Human Rights Commission that coroners will close the case. They will report to government, as they're legally bound to do in most cases throughout Australia. Those recommendations might be folded into an annual report by a state or territory government at the end of the year, but typically coroners are very frustrated that their recommendations for better police training, etc., are really being ignored. And we became aware of it, but of course we're in a slightly awkward position because, as you will know, we have no jurisdiction in state or territory matters. And many of these issues concern criminal law and enforcement of criminal procedures, which are outside our jurisdiction. So we went about this extremely carefully, as you can imagine. We spoke to every one of the coroners and their staff, and what we found was that they were all so frustrated that they couldn't achieve what they wanted through recommendations in their own state systems, that they were delighted for the Australian Human Rights Commission to take a facilitating role in trying to understand how this works and trying to understand why we haven't got standardised national reporting and we haven't got joined up thinking where so many perpetrators, of course, can move across boundaries and violence protection orders are not followed up in the next state where a perpetrator will typically have gone to avoid the consequences of those orders. So we found that they were enormously cooperative, and we also learned a lot about the death review teams. In other words, following on from the coroner's report, they will work with a death review team. But not every state has a death review team from domestic violence, and Tasmania and the Northern Territory in particular do not have them. They're very limited in funding, but they do very sensibly have an intergovernmental committee, and they're starting to move to more joined up understanding of how these domestic violence deaths actually occur. So what we've done is to start to do some more work and to produce a report that will be a report for the coroners to go to COAG to see if we can get some better approaches to the coronial processes. And as you can see from the stakeholders, we've got the Commonwealth, the state and territory ministers, the coroners themselves, and the family death review teams engaged. So we hope to report in the next 3 or 4 weeks, and we hope that that will get some political support from the relevant attorneys general, and it might be possible to develop some new reforms. One thing I did discover, much to my surprise, was that there is, of course, no Commonwealth coroner. And when a plane goes down in the sea with Australians on board, or Australians are killed in a terrorist attack like Bali, one of the state coroners will take on the job of being a coroner in relation to those particular matters. But it's an ad hoc process, and I think perhaps time has come for us to think a little bit more clearly about whether we could see the role of a national coroner being established. But we certainly need mechanisms to implement the recommendations, to provide better access to legal services, particularly in rural and remote areas. You will, I think, all be aware of the fundamental problem that we have as lawyers, and that is the reduction of funding for legal services generally, community legal services. I think over 200 of them throughout Australia have a 1/3 reduction in their budgets from the government level over the next a third each year for the next 2 or 3 years. So their capacity to deliver services is significantly reduced, and we believe that the failure to provide proper access to legal services is exacerbating the problem of women who are subject to domestic violence. They simply can't get the prevention orders through, and they can't always ensure that they're properly policed. So I think with that, I will hopefully rest my case, but I think this is really a problem that Australians now are aware of. It's been hidden behind closed doors. It's been something no one really wanted to touch. But I think now we have an environment where we have another Australian of the Year to take the matter forward. We've got a Prime Minister who seems committed to understanding the problem, and we have state governments as well starting to generate funds for more research and for better refuges and access to legal advice. So my hope is that we we can keep this momentum moving forward so that we can start to have an impact on whatever the accuracy of the figures, any death in these circumstances is too much, and certainly the deaths of these women, Pritchard and Do, are really unacceptable, partly because, of course, the impact of domestic violence does fall particularly on Indigenous Aboriginal Torres Strait Islander women, and that is, of course, a cause for great national shame. So thank you all very much, and I shall pass over. Thank you.